Hello, everybody, and welcome to History/Law Bite number 276, dated June 15th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. This History/Law Bite is entitled Cooper versus Aaron, 358 U.S. 1, 1958. Cooper versus Aaron was a landmark U.S. Supreme Court decision during the Civil Rights Movement era in American history, which held that the state of Arkansas was bound by federal court rulings mandating desegregation. And in an even greater sense, the states themselves are bound by the Supreme Court's decisions and cannot choose to ignore or defy them, but instead must submit and obey them. So, we will begin in the same way that the Supreme Court of the United States does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. Mr. Chief Justice, and may it please the court, we now dive into the facts of Cooper versus Aaron. So we're turning the clock back here, folks, all the way to 1958, all right? And as you know, that's the immediate post-Brown versus Board of Education period in American history. It goes without saying that the Brown versus Board of Education decision was a very, very unpopular one in the American South. You know, indeed, many southern states actively engaged in near militant resistance to the Supreme Court's repudiation of the separate but equal doctrine, okay? And resistance, of and in itself is an understatement, all right? It was bad enough that you had individual citizens resisting desegregation, but in many southern states, you also had governors and other elected officials openly defying the Supreme Court's mandate here, all right? So these were tough times. These were very rough times. And all I can say is I thank the good Lord I didn't grow up during this era, all right? So in this case, Arkansas is our point of origin. And in the state of Arkansas, we see the typical resistance to integration, all right? However, the Little Rock School District, all right, which was the only school district in the entire state that decided to actually go on and implement, integrating, its schools, all right? While others in the state absolutely refused to do so. As a matter of fact, the Arkansas General Assembly even passed a law, to impede integration. They passed an amendment to the state constitution to literally block integration, an act of defiance against the Supreme Court's decision, all right? So, we see, like I said, the Little Rock, Arkansas School District, doing its best, so to speak, to comply with the Supreme Court's mandate. But, there's a lot of chaos. There's a lot of resistance. You got the governor of the state and the state general assembly, doing everything in their power to impede, integration happening at all. So, the Little Rock School District continued to do so. And in February of 1958, 5 months exactly after the Little Rock 9 situation, which I'm sure you've heard of. You know, the Little Rock School Board filed suit in the U.S. District Court for the Eastern District of Arkansas, you know, seeking to temporarily suspend its desegregation plan. All right. They gave, among other reasons for wanting to delay it, you know, the mass opposition to integration, you know, and the chaos resulting therefrom, and requested that all the black children be sent back to segregated schools, and that the integration order be delayed from being implemented until January of 1961. All right, and that's a long time down the road. All right, and the district court granted the requested relief to the plaintiffs. All right, but that, ladies and gentlemen, was reversed on appeal by the U.S. Court of Appeals for the Eighth Circuit. All right, and who do you think was representing the cause for our respondent in this case, Aaron? None other than Thurgood Marshall. All right. Now, interestingly enough, the Supreme Court of the United States refused to hear this case in place of the Eighth Circuit. It wanted the Eighth Circuit to make a decision. All right, and the Eighth Circuit thankfully did make the right decision and reversed the district court holding, granting the relief to the Little Rock School Board to delay their integration plan. All right. So once the Eighth Circuit had ruled for Aaron, you know, an appeal was made to the Supreme Court of the United States on behalf of the school board. All right. Now, this, you know, was a very tense and passionate issue that the Supreme Court itself went into emergency session to hear. It heard this case on August 28th, 1958, and again on September 11th, 1958. You know, another round of arguments, and the court reached its decision on September 12th, 1958, and announced that decision on September 29th, 1958. All right. The issue facing the justices here, quite simply, was, could the state of Arkansas legitimately seek to delay and thus undermine federal court orders requiring desegregation? And the Supreme Court of the United States, a unanimous decision, said no. All right? In a per curiam opinion that was largely, however, drafted by Justice William J. Brennan Jr., one of my heroes, of course, and signed by all 9 justices, okay? Something that, like, never happens, okay? The Supreme Court ruled against the school board and against the state of Arkansas. The court held, in its per curiam opinion, that Arkansas officials were entirely bound by federal court orders requiring desegregation, and that states were not permitted to undermine or ignore the Supreme Court's decisions. The Supreme Court's decisions had to be obeyed. The opinion went on to further declare that the judgment of the Court of Appeals for the Eighth Circuit was affirmed, okay? And the orders of the district court enforcing petitioner's plan of desegregation are reinstated, effective immediately. So the Supreme Court reinstated the original district court holding, all right, enforcing the desegregation order and the desegregation plan, all right? All right. So the Supreme Court went on to further, after reinstating the desegregation plan for the Little Rock School Board, the court went on to further say that this court cannot countenance a claim by the governor and legislature of a state that there is no duty on state officials to obey federal court orders resting on this court's considered interpretation of the Constitution of the United States in Brown versus Board of Education, 1954. All right? So they obviously threw that nonsense right out the window that the state legislature and other state officials had no duty to obey federal court orders, okay, resting on the Supreme Court's decision in Brown, which of course was a constitutional decision based on the 14th Amendment. So there is no right of the state to defy federal court orders, all right, based on the Supreme Court's interpretation of the Constitution. Next, the court went on to say that this court rejects the contention that it should uphold a suspension of the Little Rock School Board's plan to do away with segregated public schools in Little Rock until state laws and efforts to upset and nullify its holding in the Brown case have been further challenged and tested in the courts. In other words, the Supreme Court refused to allow the Little Rock School Board to stop integrating, okay, so that the laws here could be challenged and tested to see whether they were truly unconstitutional in the state of Arkansas, all right? And purportedly, the goal that Arkansas was trying to do was get the court to undermine its own holding in Brown. Not going to happen. They went on to further say that in many locations, obedience to the duty of desegregation will require the immediate general admission of Negro children, otherwise qualified as students, for their appropriate classes at particular schools. Number 4, if after analysis of the relevant factors, which of course excludes hostility to racial desegregation, a district court concludes that justification exists for not requiring the present non-segregated admission of all qualified Negro children to public schools, it should scrutinize the program of the school authorities to make sure that they have developed arrangements pointed toward the earliest practicable completion of desegregation and have taken appropriate steps to put their program into effective operation. All right? Next, the petitioners stand in this litigation as the agents of the state, and they cannot assert their good faith as an excuse for delay in implementing the respondent's constitutional rights when vindication of those rights has been rendered difficult or impossible by the actions of other state officials. All right? So they can't delay implementing an individual's constitutional rights here just because it's been hard to implement them. All right? That is not good enough, folks. All right? Just because the state officials say it's difficult or impossible when they weren't even really trying, all right, is not a good enough excuse to delay implementing the court's desegregation orders. Next, the constitutional rights of respondents are not to be sacrificed or yielded to the violence and disorder which have followed upon the actions of the governor and legislature, and law and order are not here to be preserved by depriving the Negro children of their constitutional rights. I think that's pretty straightforward. Next, the constitutional rights of children not to be discriminated against in school admission on grounds of race or color, declared by this court in the Brown case, can neither be nullified openly and directly by state legislators or state executives or judicial officers, nor nullified indirectly by them through evasive schemes for segregation, whether attempted ingenuously or ingenuously. All right? Next, ingenuously or ingenuously. All right. Next, the interpretation of the 14th Amendment enunciated by this court in the Brown case is the supreme law of the land, and Article 6 of the Constitution makes it of binding effect on the states. Anything in the Constitution or laws of any state to the contrary, notwithstanding. All right? So the court has interpreted the Constitution, all right, and its decision is the law of the land, and thus protected, and its authority affirmed by the Supremacy Clause in Article 6 of the Constitution. And any state law or constitutional provision that says anything to the contrary must fall. In other words, it cannot be implemented if it goes against the Supreme Court's decision here. All right? It's the Supremacy Clause, by the way. Number 9, no state legislator or executive or judicial officer can war against the Constitution without violating his solemn oath to support it. Got him. So all these Southern officials who are openly defying the Supreme Court's decision in its interpretation of the Constitution are effectively warring against their own oaths, breaking their oaths to the very Constitution that the Supreme Court has interpreted here. All right? When you take an oath of office, you almost always take an oath to support the U.S. Constitution. All right? And since they're disagreeing openly, violently, defiantly against the Supreme Court's interpretation of the Constitution, they are violating their oath to support it, and however the Supreme Court interprets it. All right? Last but not least, state support of segregated schools through any arrangement, management, funds, or property cannot be squared with the command of the 14th Amendment that no state shall deny to any person within its jurisdiction the equal protection of the laws. So that simply put means state support of segregated schools plainly and indisputably goes against the command of the 14th Amendment's Equal Protection Clause. All right? State can't support segregated schools. All right? Through any arrangement, management, funds, or property. Doesn't make a difference. All of it, any support of segregated schools goes against the federal Constitution, the 14th Amendment's Equal Protection Clause. So with that, the Supreme Court affirmed the holding of the 8th Circuit Court of Appeals. Okay? Now, Justice Felix Frankfurter authored a concurrence that emphasized the importance of judicial supremacy and expressed his disdain for the state of Arkansas's obstinance, all right, and refusal to implement desegregation as required by the federal courts. So, the legacy of Cooper versus Aaron is quite secure. The decision sent, an indisputably strong message to the recalcitrant southern states, not hardly just Arkansas, by the way, that it would not tolerate obstinance or defiance, all right, of its decisions. Southern states had to comply with Brown 1 and Brown 2, and the district courts could set appropriate sanctions upon state officials for defying federal court orders, all right? Whether those orders be from the district court itself, all right, or through implementation of the Supreme Court's holdings, all right? Federal district courts are essentially, the real enforcement arms of the Brown decision in the judicial sense, all right, as they had the power to impose sanctions, contempt of court, fines, and other things for state officials not complying with the Brown decision, all right? The decision affirmed, essentially, in case anybody was in doubt, by the way, that the Supreme Court of the United States had the final say on the meaning of the Constitution. All right? Like I said, if anybody was in doubt of that, the Cooper versus Aaron decision gave you an update on it and had to remind you for a second. Okay? And the states, no matter how much they disagreed with the court decision, couldn't ignore or defy the Supreme Court's rulings. All right? They had to comply. End of story. Point blank. End of it. So, once again, the holding of the Supreme Court in Cooper versus Aaron was that the states are bound. The greater effect of the decision, the states are bound by the Supreme Court's decisions, all right? Most especially decisions in its interpretation of the Constitution, and that states cannot ignore or defy those decisions, but must obey them and implement them accordingly. So that is Cooper versus Aaron, 358 U.S. 1, 1958. All right? So I thank you so much for listening and tuning in. If you made it this far, give yourself a pat on the back, because I know some of it may have been a little technical and difficult to understand. But at the end of the day, I'm here to help explain it wherever you might have been confused. So, if any questions or controversies, leave them down below and I'll be happy to answer them. If you like this video and got some insight out of it, drop me a like on the video. That would be graciously appreciated. And if you've not subscribed to my YouTube channel, I humbly invite you to do so now. Your support means more than you will ever know, ladies and gentlemen. All right? So again, thank you so much for listening. Take care. Stay safe out there. And I'll talk to you at the next bite. Peace.